Today is the 10th of June 2020. Case number 667 of 2020, severe and for others.
As the court pleases, my lord, for the state, the appearances are still the same. Balwe GD assisted by R.C. Banda.
As a please the court, my lord, I'm hereby confirm my representation of accused number 1 to 4, Advocate Mandesala Tefo, instructed by Attorney Titi Tobani.
As the court pleases, my lord, the appearances on behalf of accused number 5 is before, my lord, as the court pleases.
My lord, there are two preliminary issues. Advocate Tefo has just asked for some few minutes to address you. Thereafter, we'd also want to say something before we proceed with the day's proceedings.
Yeah. Okay. Your Lordship, I think I can give my senior, the state, a chance. I can come later.
Well, whatever you are going to say, will you not have to respond?
Pardon?
Will the state not have to respond on what you are going to say? Because, I mean, what was the use of you saying something and then he saying something, you say, I mean...
even my learned defense will respond, even the court will respond. That's why I needed the state to say first.
What I'm saying is that if anybody has anything, any motion to push, it's presented and the others respond. That's the way we should do it.
The reason I prefer Advocate Baloy to say it first, what I may say, there is a possibility that it may supersede what he will be saying.
As the court pleases, my lord, from the state, two issues. The first one relates to the debate we had yesterday about the original CD that Advocate Mshololo requested. We have that CD, my lord, available with the raw photos, and we have explained that to Advocate Mshololo that this CD is available for her use. Then the second issue, my lord, is Advocate Mshololo put it to the witness that Mrs. Kumalo slept at the house on the evening of the 26th of October, 2014. And at that stage, my lord, we made an objection and indicated that there's no basis for her to say that. She then intimated that slept at her house on the night in question. We had a discussion with Advocate Mshololo yesterday in the morning before we resumed about this point, and also this morning. We just want that to reflect on record, my lord, that as we raised that objection, that the statements have been scoured and there is nowhere where it's stated that she slept at the house. Thank you. Those are the two issues, my lord.
Advocate, therefore.
As it please the court, Your Lordship, thanks for indulgence. As the counsel for accused 1 to 4, Your Lordship, My client were previously represented by the legal aid judicase. So I came in officially on the 17th of March when the disclosure was made on both the case dockets 63610 2014 and 37501 2019. That's where your brother, Judge Bam, said to me I should indicate, because the case were to start on the 11th of April. I should indicate before the 28th of March about my readiness, as I was Johnny came late. I did my level best to try to make a catch up. I've done the best that I could, so that for the beginner I can be able to start. Your Lordship, I'm standing as I'm standing here because of the new discovery insofar as this matter is concerned. Being that the continuation of this witness today, if my learned colleague has to continue, it will be a futile exercise. Why? It's because it has been discovered that my client, including accused number 5, they made a first appearance in Boksburg on the 20, I was thinking I'm right to say the 26th of October 2020, but my client corrected me to say it was the 27th of October 2020. It was when they appeared in Boksburg court at 10 o'clock. The heinous discovery is that Your Lordship, that they've appeared at Boksburg court, for which I will stand to be corrected. I will still be using my date that I thought it was correct, which was 26th of October 2020. I measured the date of the 26th of 2020 October on the basis of the press conference of South African Police Service, which was addressed by the Minister of Police, the former National Commissioner, General Ketla Sithole, and the late Lieutenant General Mfazi, here in Pretoria, whereby the minister said there is a breakthrough in the Senzo Meyiwa case, whereby 5 accused have been arrested in KwaZulu-Natal.
Advocate Tefo, some of the information you are spending time giving is not really useful for our people.
Okay.
I want to know what is the gist of your address. What do you want?
Let me shoot straight to the point, Your Lordship. My client, as they are here, in terms of accused number 1 to 4, they were never informed of their rights. When they appear in Boksburg on the 26/10/2020, they came before the court. They were not charged. They were not informed their reason why on the 26th of October 2020 they have to be at Boksburg court. That's where the whole South Africa, for the very first time, saw the accused refusing to enter the box, saying, "We don't know why we are here. We were never informed of our rights. We believe that the people who are supposed to come here, they do have money and they cannot appear. We are poor. We are being scapegoated to avoid." for the police or the NPA arrest and prosecute the relevant people. So, Your Lordship, I hereby say, hence I'm saying, the continuation of the cross-examination of Mr. Msia, it will be a futile exercise to my client whose rights were violated. It will be as if it is a business as usual, whereas it's not. And if myself, I can also be participant. Unfortunately, I've already been participated, but that participation, it was oversight. That this discovery was not yet realized. That's where, Your Lordship, I'll say that should I don't want to be accomplice to the violation of the constitutional rights of my client.
The long and the short of what you're saying is that the accused number 1 and up to 4 today raised issue with the fact that when they appeared in Boksburg, their rights were not explained, and as a result they even refused to enter the accused dock, and you learning of that, because you are saying you came late onto the matter, you have grown to be reluctant to participate further in this trial. Is that what you are saying?
I'm saying yes, it's a part of that.
Yeah.
Further to that, I'm saying that as I remember back when my learned colleague, Advocate Baloyi, he penned as a dominus litis the manner in which this trial should be shaped, whereby initially I even raised before this court, but I was shot down, whereby from the side of the accused 1 to 4, we meant that there should be a trial within a trial. Why so? Because there is, we acknowledge, there is confessions by accused 1 and accused 2. And accused 1 did not only do the confession.
I don't understand why you speak about being shot down about a trial within a trial when this trial is still on. I mean, a trial within a trial can happen anytime.
Okay.
I don't understand why now you are saying you have been shot down.
Shot down
as if you are initiating a trial within a trial and it's being refused.
not in a very adverse way, Your Lordship. Shot down, I may not maybe having the specific way of saying that, because I remember very well that I did raise the issue that there is a confessions. So I even say it's a tried law that if there is a confession, then the confession, if we don't admit, we are denying, or we are, the constitutionality of the confession and the admissibility of the confession are in limbo, are in question. Then, therefore, there should be a trial within a trial before we can consider the main trial, like now, as it is now.
The strange thing here is that I'm hearing from you about a confession, when whereas what I'm used to is that if there is a confession which the state intends to rely upon, it will introduce it, and it is then that you are going to respond to that. And that may even lead to a trial within a trial. As to why we are having this debate, me and you now, with nobody having suggested the use of a confession yet, I don't understand. I think, are you not ahead of yourself on that score?
I'm definitely not ahead of myself, Your Lordship. Actually, I am late instead of being ahead of myself. I'm very late to come and introduce this, because I say that confession was obtained after my client, accused 1 and 2, were extremely assaulted.
Yeah, well,
yes.
Yeah, I don't know, maybe you are late, but for me, there is no confession in issue before me. I will have to state where I got it. Otherwise, I got it from the bar, from advocate.
Yes.
Therefore.
For our case 124.
That is the reality about it.
Yes.
If there is a confession, indeed, my belief is that it will come. And whoever is affected by it will respond in accordance with the procedures that are laid.
Hence, I'm saying, Your Lordship, yes, the court will not know. It has to be informed by the party, especially the defense, if there is any violation of the clients of the defense.
Yeah, but
rights.
I also cannot be party to a procedure where there's I hear about a confession that will be used from a defense counsel, because the state must state its intention to use that confession. Whoever is affected will accordingly, in accordance with the procedures that we use in courts of law, will respond. And then if everybody has said their say around the confessions and they've argued the way a trial within a trial is conducted, then I will make my ruling. But now you're pushing me into something I don't know. I must repeat, I don't know. Even after you have reasoned and spoken about it, I don't know it.
You don't know, Your Lordship. I'm aware. That's why I'm standing here.
Yeah.
And I'm introducing this.
Anything else?
And can the Lordship give me the opportunity to speak, please?
Yes.
To address this court?
Yes.
Yes. I mean, it's not safe to argue between you and me. And I didn't invite the argument. I just wanted to make a submission. That's why I've requested my legal colleague to say.
Finish
Yes.
what you want to say.
Yeah, and it should be not that I should not be expedited.
Yeah.
This is very important for my client, and I have to do my best to
The
defend
same
my
as
client.
you are not going to tell me how to run my trial, Advocate Tefo. You are not going to tell me how to run this trial. The tail in this instance shall not wag the dog in my name.
It's not what I'm doing to tell the court how to run the proceedings.
Yeah,
What
and
I'm saying,
finish your argument, so that we give others the chance to respond.
yes. What I'm saying, Your Lordship, is that having realized or discovered that my client's constitutional rights have been violated, we hereby want to make submission that there should be a trial within a trial, whereby we can be given an opportunity to bring that application and support it. Hence, as I'm saying that, to proceed as if this is a business as usual is a risk to my clients. Thank you.
Advocate Nshololo.
As the court pleases, my lord. My lord, with due respect, my lord, to my learned friend, I've never heard, my lord, wherein the defense has to tell the state what to do. We will wait for the state, and the state is the dominus litis, and the state is the one that is going to make submissions before this court regarding the statements and the evidence that the state wishes to make. And at this stage, my lord, I will ask for protection because it is my time to continue with the cross-examination. My learned friend had his time and he did not, what he's saying right now, he ought to have said it during his time when he was cross-examining this witness. And I cannot, with due respect, my lord, be told that it's a futile exercise for me to cross-examine this witness. As the court pleases, my lord, those are my submissions.
Yeah, exactly what I foresaw, that Advocate Ngobeni, you will then have to respond to the submissions made.
As the court pleases, I must state from the outset that I'm a bit at sea as to the nature of the request. Well, firstly, my learned friend mentioned that accused 1 to 4 were never informed of their rights when they appeared in Boksburg. They were not informed why they had to be at Boksburg court. But in the same breath, it was mentioned that they were not charged. So it's not clear to me, firstly, whether is a contention that, they were not properly charged. And secondly, is the contention that when they appeared at the Boksburg Magistrate Court, they were not informed of their various rights. It's not clear to me as to whether is reference here being made to the right to legal representation, or precisely what the nature of the contention is. But in the same breath, mention is made of confessions that their constitutional rights have been violated. And as the court pointed out, when we get to that stage during the trial, within a trial, they can then raise as one of the grounds on which they challenge the admissibility of any evidence that the state intends.
While you are on that point,
Yes.
sorry to
Yes.
interject. I tried to raise this with Advocate Tefo to say, are we not getting ahead ourselves if we
Yes.
speak about that? Because as I sit here, even now, despite your short response, I don't know if there are confessions to
Yes.
be dealt with. I don't know.
Yes.
I only had somebody in court telling me that there will be confessions to be dealt with. And
Yes.
I did try to say that maybe we should allow that process to unfold, and if that happens, whoever is affected, will deal with it
Yes.
as they deem fit. And as you heard, your sister is also complaining, because all that is happening now is happening at the expense of the opportunity of Advocate Mshololo to
Yes.
continue with cross-examination, which may even distract her from her own point.
Yes.
So if you were to be, I'm not saying you are long-winded, if you were to cut to the
Yes.
bone and state your point, so that we'll give him the opportunity to reply, and so that we cease disadvantaging Advocate Mshololo and their client.
Yes, we're trying to wade through the submissions just to try and establish what is the nature of the relief that he's seeking, because at first blush, my lord, my understanding was that he's saying that the accused are wrongly before this court. They are wrongly brought before this court. And I thought, well, if that is the contention, then, proper affidavits will have to be filed, a notice of motion will have to be brought, and charge sheets filed. But when I thought that was a contention, then the issue of the confession, was raised. All I'm saying, in short, my lord, is it's not clear to me at this stage as what is the nature of, the relief that is being sought. But be that as it may, my lord, we are of the view that if the question is whether the accused are properly before this court, then that is the issue that will have to be brought by a notice of motion supported by the necessary affidavit. If the issue is the admissibility of any statements that might have been made by the accused, we will cross that bridge when we get there during the trial within a trial.
Thank you, my lord. All this submission I made, being fully aware that the court is not aware, and it is incumbent upon myself as the defense of accused 1 to 4. And it's unfortunate. And it's unfortunate. Here is a matter of weighing the unfortunate part of it and the continuation of Advocate Mchololo with the cross-examination. It will always, when it happens, one or other part will be in a disadvantage. And I may say, luckily enough, the party that feels that is in a disadvantage is the party that's supposed to pay a due diligence to accused number 5. As Advocate Mchololo is my learned colleague and is my fellow defense, there is no way. I will find it very much strange and bizarre for her to justify her continuation, despite the fact that I'm saying your client's rights, constitutional rights, has been violated. During the beginning of this case, she was the most person who's talking about how to protect the rights, the constitutional rights of her client. It cannot be now, when she feels that it suits her to continue with the cross-examination of Mr. Msia.
It sounds like a lecture to Advocate Mchololo, which is...
I am responding, Your Lordship.
Say your say, respond to what they have said, and let's proceed. Not what Advocate Mchololo should do about his case.
I have to respond for what they are saying, because she's saying, I'm saying that continuation is a gross violation of our client's rights. And myself as an advocate, as a counsel of 1 to 4, I'm bound by the ethics to pay due diligence to my client. And so applies to her. She's also bound by the ethics to pay the due diligence to her client. So her part I cannot, fortunately enough, I cannot have much to say about that. I've said enough once I say due diligence has to be paid to accused number 5, as I am doing to my client. And as for the state, Your Lordship, state has been disingenuous from the beginning. This court was not aware of 2 case dockets from the police with a different theory, with a different investigating officers. We've got the situation in the South African Police Service whereby the members of South African Police Service are in collision course, which is not helping to the justice in this country. You cannot have the situation whereby for the same incident, you've got a different case for different theory. That's why we are saying that for case number 636, which wrongfully brought my clients here, that's where we are facing it now. And I'm raising this in pertaining to that one. And there is also the case 375, which is opposing. In essence, 375 is opposing the presence of my client in this court, because saying there are relevant people who are supposed to be charged, and those relevant people who are supposed to be charged will be tried in the South Local Division, Johannesburg. And here, further, we mooted about this with my client, with my attorney, that honestly speaking, Your Lordship, we don't even know today why we are in North Gauteng today with my client. Well, the scene of crime, the jurisdiction which has to be inherited by the Johannesburg, South Gauteng. So, for the state.
Just on that point, there is a section, I won't tell it offhand, in the Criminal Procedure Act, which empowers the Director of Public Prosecutions to determine the venue of a trial of any case within the Republic. So are you saying that are you saying that we should not have regard to that? Because in this case, this one, the Director of Public Prosecutions has determined that this trial will be run in Pretoria. And I can even say it's not the first that this happens. So are you saying that even that I should not consider that whoever brought this trial to be in Pretoria did it in terms of a section in an act?
We strongly believe that the NDPP to have earmarked this local division, the North, for the scene that happened within the jurisdiction of South Gauteng we find it very bizarre. And we don't even understand. We are given this page. We don't even know sure that it was signed by her, Advocate Batoi. We don't know her reason. Why should she bring this matter here? I'm not denying that. I'm not refusing, but I'm not denying that procedure or process to say, yes, the Attorney General in the NDPP can say that. But in this case, it's a strange for her. And we may even need her to come here and explain why did she bring this matter here. Well, that is definitely questionable.
Okay. Is that all?
No, I was still on that to say, with the state, I've learned to understand that the state will always act disingenuously, especially in this matter. I said, number one, this court was not aware of 2 dockets.
No, you are repeating yourself.
And then,
now
number
you are
2.
repeating yourself.
Let me
You are
finish.
repeating no,
please.
no, no. That's
I'm saying
why
number
you
2.
and me fight. Let's not repeat, because I have 2 ears that still function. When you say things, I hear. And I was even writing. Now we are going back to the same issue about repetitions.
I don't see what you are writing, Your Lordship. That's why I'm saying, I just did for the confirmation. Because
Even
I'm
if I
responding to
didn't
you.
write, I heard it.
Okay. All right. I'm progressing. I say number 2.
Yes.
Yes. Disingenuously so and deliberately so, the state say, we even discuss about this, myself and the state. We discuss the defense for 1 to 4. Yes, we see, we acknowledge the confession, two confessions for accused 1 and 2, whereby the confession was obtained after assault GPH of my client, accused 1 and 2. So it cannot be now that we come before this court, is a business as usual. My client are sitting there, despite the fact that they've been assaulted. They are listening all this evidence that is so irrelevant to them because they were brought wrongfully so. As a result of that, because it will always, in our consultation, that they will bring issues that may be of a disturbance to them or violating their constitutional rights. So is that. And the state, Your Lordship, we can say without a fear of contradiction that there is nothing insofar as linking my client to the charges, charge 1 up to 5. Nothing except the forced confessions whereby it was obtained after the assault. So any other thing, and I've got the 4 clients, Your Lordship. Accused number 1 and 2, they were not supposed to be in this court. If they were supposed to be in this court, they're supposed to be coming from outside, not from where they've been jailed. Because the first presiding officer at Boksburg was misled by the state for him or her to sign J7 to say, go to jail. Initially, accused number 1 and 2, they were outside. I had only 3 and 4 who were serving sentence of different matter. So it cannot now be that my client are even now, as we are speaking, accused number 1 is in Binoni, is in jail, Moda B. Accused number 2 is now in Kosimampuru, where he is been put in a humane way. Where he stay in that cell is not suitable for the human condition. So I therefore say, Your Lordship, having said and having brought this to the attention of the court, which is a court of equity, this court, if my human rights or the human rights of my client have been somehow affected, this is a bodyguard for the constitutional rights of my client. And therefore, I cannot be part of perpetuating the criminal activity in terms of the constitutionality in the rights of my client to be proceeding here. The evidence of Mr. Musia can always step down and he can be called. later on, if it has been established that the accused's rights were not violated, because I'm now challenging that. I'm challenging the state to say, we cannot proceed until we have a trial within the trial and verify that my clients are correctly here. That's my standpoint, Your Lordship.
Having listened to Advocate Defo, having listened to the Advocate for the State, Advocate Ngobeni, having listened to Advocate Mshololo, the court wishes to express as follows. It has come to light that Advocate Defo and his clients have issue with the facts around number one, the first appearance that happened in Boksburg, in the sense that that appearance was not preceded by an explanation of the accused's rights. And therefore that appearance is questionable or was questionable. The second is that there are supposed, or according to Advocate Defo, because for now I don't know, according to Advocate Defo, there are confessions that may come into play in this case. And he wants, and he almost demands that this trial stops so that those confessions be dealt with. Regarding both issues, I must say that they have not been properly brought before me. They came by way of evidence adduced by Advocate Defo from the bar. And as a result, unfortunately, in that regard, they couldn't be said to be anything before me around those issues. If I say they are, I would have to tell how I regard them as before me. Because in this country, we have set rules of procedure, be it criminal procedure, be it civil procedure. There's a given way in which we do things. In any case, I gave the state and Advocate Mshololo the opportunity to respond to the submissions being made by Advocate Defo. The Advocate for the State almost repeats what I'm saying, to the effect that if there are confessions that are contended, we will cross that bridge when we come to it. Advocate Mshololo didn't spend much time around the submissions being made, but she made a pointed finger or a pointed issue which cannot be contended with, especially by myself, that as far as she knows, we have been running this trial. Evidence was led by Mr. Musia. Advocate Defo was given all the time in the world to cross-examine without interference, to cross-examine Mr. Musia, and that process came to conclusion. It is now the opportunity for Advocate Mshololo to proceed with cross-examination before she even loses track. I'm not saying she's capable of losing track. Let me say, before we even distract her with this other issue which should not be on the table, because it is not even before the court now. because it was never properly brought. And having listened to all of that, I rule, having heard that there is reluctance on the part of Advocate Defo and the people he is representing, there is reluctance in continuing with this trial. He calls it criminal to continue with participation in this trial. I rule that this case, these proceedings continue. I rule that Advocate Mshololo, sorry about that, who was busy cross-examining, shall be given the opportunity now to continue with cross-examination.
The court please, my lord.
The court, please, Your Lordship. The ruling being accepted, however, we want to make a note that we will bring a formal application for the trial within a trial. By Monday, we request that it be addressed before this court, whereby the state will be served, Advocate Mshololo will be served. Thanks God, it's Friday today. We have opportunity this weekend. Thank you, Your Lordship.
Advocate Mshololo, I must apologize for all this.
As the court please.
You were not supposed to be interrupted, but then the opportunity is yours.
As the court please, my lord. Sergeant Mosia.
Yes, sir.
Let us continue where we ended yesterday. Can you just wrap up on the date as to when the exhibits contained in page 113, page 13 of Exhibit A were submitted to the ballistic?
Exhibit A, page 113.
Page 13.
Or is it 13? 13. Hore I submit to Bafani Kanani.
But it dates October.
It was submitted on the 30th of October 2014.
Sorry, just something else. I forgot to warn you that you are still under oath, Mr. Msia.
Confirm my lord.
Ilanga noma idate ebuzo advocate ukuthi ke ama exhibits lana ahanjiswa ninike kwakuyi 30 zika October 2014.
Okay. So it means the memorandum was prepared on the same date and they were also submitted on the same date.
Le memorandum o hlophisitswe ka lona tsatsi leo ya ba di romelwa le ka lona tsatsi leo. That is correct.
Kusho ukuthi ke yebo nale ncwadi ke ngayibhala noma ke memorandum yenziwa ngaleli langa lange 30 October 2014 zabe nazo ke sehanjiswa ngalelo langa.
Where is the proof of the delivery notice of those exhibits? We're talking about exhibits that were packed as per the PA number that you just referred this court to yesterday.
Jwale he bukae bopaki bo bontshang hore di ile tsa ntshuwa tsa amohelwa tsona di exhibit tseo di hlalositseng ho ya ka di PA numbers tsena re bua ka tsona maobane.
And the PA number, if I can just remind you that you said these two exhibits were put into one bag and it was a seal bag number PA 50020877782. Am I correct?
Ki yona PA number e ho banu la hlalosa hore bopaki bona bo ile ba kengwa ka hara mokotla o le mong wa ka serial number eo ya PA 50020877782.
Ekinet.
That is correct.
Kuyiqiniswa-ke ukuthi bengishilo-ke nabo ubufakazi bami-ke ukuthi bathathwa-ke lobo bufakazi bafakwa-ke kulesi sikhwama sobufakazi esiwu-PA 5002087782.
Okay. Maybe before you tell us, or before you tell this court about the acknowledgement of receipt, how were these exhibits submitted to the ballistic?
Pele re ka kenella ho taba tsa bopaki bo re batla ho tseba he hore o ile lile la fana ka bona ka tsela e feng ho ba ballistic tsela e le latetse meja.
Ke nahane ka tsona ka matsoho.
They were hand delivered at the ballistic.
Where is that?
Laphayana-ke kuma-ballistic yimina-ke nganikezela ngabo ubufakazi ngezandla.
Where is that proof?
Bokae bopaki bo ba hore di ile tsa isiwa ka letsoho ballistic?
By way, remember now, I want to remind you, when you submit the exhibits at the ballistic, they give you the acknowledgement of receipt.
Re o hopola hore ha ba o isa dintho ballistic tlamehile ba o fe receipt e bontshang hore ba di amohetse.
Did they give you the acknowledgement of receipt?
Ba o file receipt ya mofuta o jwalo.
Ho jwalo.
Where is
They
it?
did give me the acknowledgement receipt.
Where is it?
Banginika-ke iphepha noma irisiti-ke eshoyo-ke ukuthi bakwamukela noma ubufakazi lokho bakwamukela.
Where is it? The proof, the acknowledgement of receipt, that this is the proof for the exhibits that I submitted to the ballistic.
E ho kae he proof e bontshang hore ba ile ba o fa receipt ya hore ba amohetse dintho tseo.
E tlameha e be le provincial office ya crime scene management.
It's supposed to
Filing.
be in the file at the office in the provincial office of the management crime scene.
Lokho-ke noma leyo ncwadi-ke noma lobo bufakazi obushoyo-ke ukuthi ubufakazi babamukela kufanele ukuthi-ke isehhovisi-ke lesifunda le-crime scene management.
And this court cannot go to that docket. You are the one who are supposed to bring that. Am I correct?
And o tseba hantle hore
But this acknowledgement has been handed up and it's on page 12 of exhibit A3. It's A3 in brackets 2, my lord. It's just after the letter addressed to the forensic science laboratory.
There you are.
My lord, that is misleading the court, my lord. This is not the acknowledgement of receipt that was given to Mr. Mosia when he delivered this exhibit. Am I correct, Mr. Mosia?
are ha se nnete hobane phepeshana e ba buang ka yona kapa tokomane eo ha se yona e wileng wa ifua ka nako o lo fanang ka dintho tsena ballistic ka letsoho.
It's not the one that you were given to
Ha
when
se e
you
wena o
delivered
ile
the
wa
exhibit.
amohela ka letsoho la hao ha o no lo o isa bopaki bo. Na ho jwalo.
Eke copy.
Yes, this one is the copy.
Lena-ke ekhulunywa ngayo noma-ke asho umshushisi ukuthi ikhona-ke iyingxenye yobufakazi phambi kwenkantolo noma kwifayili ikhophi yayo.
Mr. Mosia, don't waste the court's time. Just speak the truth. This is not the receipt that you were given at the ballistic when you delivered the
A re kopa o
exhibit.
bue nnete hobane o hlapantse o bua nnete fela. Ena ha se phepeshana e ba o fileng yona jwalo ka acknowledgement of receipt ka nako eo wena o no isa dintho tsena ballistic.
Ho jwalo.
That is correct.
So it's not correct.
Iqiniso-ke ukuthi ayisona-ke leli iphepha noma-ke lokhu abashoyo bavumayo ukuthi baphole ubufakazi.
So it's not correct what Mr. Baloyi is submitting before this court.
Jwale ha se nnete se buiwang ke Ntate Baloi a sejo tsa lekgotla.
Ke tjho hore eke copy ya original. Original e tlamela e be tholahala ka hara docket e leng hore e faetswe Johannesburg.
You are saying this is not the receipt, but it is.
It's a
It is
copy.
not. What you are saying is that it is not the original receipt. It is a copy of the original receipt you were given.
Ho jwalo mongaji.
That is correctly so.
Kunjalo-ke ukuthi lona-ke akusilona-ke leli engalinikezwe iphepha kodwa-ke ikhophi yalo lelo engangenikeziwe.
So you're supposed to be clear with this court to say you do not have the original. And where is the original?
O tlamehile o be o hlakise ha batsi pela lekgotla lena wa le jwetsa hore wena ha wa tshwara original o bo hlalosetse lekgotla hore original hantlentle e hokae.
How should this court accept the evidence to say these exhibits were delivered to the ballistic when you cannot produce the original document as proof that you delivered these documents to the exhibits?
Jwale lekgotla lena le tlamehile ho amohela jwang le dumele hore wena o ile wa isa di bopaki bo ballistic ka letsoho wa bo wa fumana receipt empa house na original ya teng.
I seriously fana ka bothata ke a dumela.
I believe that will give bring problem if there is no such.
Ngiyavuma-ke ukuthi lokho kuzoletha inkinga uma ngabe-ke leli engangilitholile-ke ngamanye amagama-ke i-original ingekho lapha phambi kwenkantolo ukuthi inkantolo izokwamukela kanjani ukuthi ngaphambilisa ubufakazi ngase ngithola nephepha elishoyo ukuthi bakuthola.
Thank you, Sergeant Mosia. It will give this court a problem in accepting this evidence. Thank you for that answer. Thank you. Let's proceed.
I know my learned friend doesn't mean any malice, but I think the use of the word mislead is ill-considered, and I suppose my learned friend will see it fit to withdraw that, my lord.
Advocate Inshallah.
Misleading, I don't remember myself saying that. If I said so, I've just withdrawn for the sake of progress, my lord. But I got what I wanted from the witness. I'm just there. I don't want to lose the focus now. If I happen to use that word, my lord, with your respect, I withdraw it.
But not add for the sake of progress. You withdraw it.
Thank you, my lord.
Okay, yeah, let's proceed.
Now the exhibits are, we don't know where they are because there is no proof for the delivery at the ballistic. But let's leave it like that.
I don't know what is meant by that. We just pointed out to the existence of exhibit A3 in brackets 2. It's not the original, it's the copy of the original. If my learned friend insists on the original, then yes, arrangements can be made in that regard. But it's wrong to say that there's no proof of delivery. When the witnesses testify that he himself personally delivered the exhibits at Ballistic and that he got acknowledgement of receipt.
Yes.
My lord, I don't want to waste this court, my lord, arguing on this.
Yeah.
It's a matter of argument when we are making our closing argument,
okay.
my lord. But for the sake of this witness,
Okay.
we don't know where we left the exhibits. We do not have proof. Let's go back to the crime scene. The same Canon Love, who had not given you the address for the crime scene, is it correct that you found him at the crime scene?
Canon Love. Is it Ndlovu?
Canon Ndlovu.
Ndlovu. Okay. What was the question?
The same Canon Ndlovu who had not given you the address for the crime scene. Is it correct that you found him in the crime scene already?
Yena Colonel Ndlovu ya sakang aufa address ya sebaka sa ketsahalo. Na ho jwalo hore ke o ila fumana yena sebakeng seo sa ketsahalo.
Ho jwalo mre.
That is correct.
Weqiniso-ke ukuthi loya Brigadier Ndlovu ongazange anginikeze ikheli ngamfica-ke ekhona lapha kwindawo yesehlakalo.
Were you not surprised how now he is at the crime scene when he had failed to give you the address for the crime scene?
Hawaka wa makatswa ku mo fihlela mo ka moraora a sa o fa sebaka sa ketsahalo re address e re.
Che anka ba ka makala ke sa tsebeng hore o fihlile neng ho etsahala eng.
No, it did not surprise me because I did not know as to when he arrived at the crime scene.
Listen, Mr. Musia.
Ngingazange ukuthi ngimfice lapha ngoba ke ngingazi ukuthi uwafika nini lapha.
Mr. Messiah, you are also a human being when you are in that witness box.
Hopola hore o motho ha o le ka tlase ho kanotje.
Were you not surprised by finding someone who is Kenan Ndlovu at the crime scene who had failed to give you the address of this very same crime scene that you found him in?
Wa ka wa o makatsa hore o fihlela Colonel Ndlovu mane sebakeng sa ketsahalo a hlolehile hore a o fe address ya hore ketsahalo e etsahaletse ho kae.
nka se kgone ho hlalosa maikutlo a ka mora dilemo tse kana ka lona letsatsi leo hore ke la ka ikutlwa jwang nka se kgone ho hlalosa.
I cannot explain as to how I felt on that day in question, especially after this matter had took so long.
Angeke ngisho ukuthi ngaleli langa ngazizwa kanjani ke ukuthi ngamangala zange ngimangale yini ikakhulukazi ke uma ubheka isikhathi eside lelicala elasithatha.
Yeah, but on that day, on the date of the incident, were you in your sound and sober senses when you had the crime scene?
Kaza sileo la ketsahalo ha o fihla sebakeng seo now no hlaphohetso.
Ke ne ke hlaphohetso.
I was in my sober senses.
Okay, were you able to see everything that was happening?
O khona ho bona tsohle tse ne di etsahala sebakeng sa ketsahalo.
Ho jwana.
Yes, I could appreciate everything.
Ngibona konke ke insemcabangweni yami ngokupheleleke ngibona konke okwenzekayo ngaleli langa.
Okay. Then I expect you to answer the question as a police officer now. Let's move away from expect. Police officer now.
Re tla kopa wa rabele jwalo ka leponesa e seng jwalo ka setsebi.
Did you at any stage interview the people who were inside the house at night on the day in question?
O ile wa hloma dipotso batho bao ba fihletseng ka hare ho ntlo bosiu boo ba ketsahala.
Che anka ba ka ba hlaba dipotso.
No, I did not interview them.
Angizange ke ngibabuze imibuzo noma khalephakathi imibuzo abantu engabafitha belapha endlini ngalelo busuku.
Why not?
Hobane o ile a ska etsa jwalo.
Ke ne ke se fumane dintlha ho Brigadier Ndlovu ke bona seo ne se bohlokwa ba ne se fumane dintlha tsa hore ho etsaetseng.
I did not see that necessary to do because I had already received the information from Brigadier Ndlovu.
Angizange ngikubone ke kuyisidingo ukuthi ngikwenze lokho ngoba ke ngase ngitsheliwe ke noma ke ulwazi noma imininingwane nginyikiziwe uyena uBrigadier Ndlovu.
So you decided not to do your own investigations from the people who were present inside the house and relied on instruction by Kenan Ndlovu. Is that what you are telling this court?
Now batla hore wena ha wa iketsetsa dikhuputso tsa hao ro tsebe ho fihlella utlwe ho tswa ho batho ba hore hantle ntle ho etsahetseng o ile itshetleha ho se builweng ke Brigadier Ndlovu kapa yena Colonel Ndlovu.
Ho jwana.
That's correctly so.
Kuyiqiniso ke ukuthi ngathatha isinqumo ke sokuthi ngakwenzi lokho kodwa ke ngithathe nje lokho engakushola uyena uBrigadier Ndlovu.
Okay. Thank you, my lord. Did you take from the people who were inside the house any gunshot residue from their hands in order to test if there is anyone who was inside the house when the incident took place who had fired shot?
Ho batho ba ne ba le ka hare ho ntlo na o ile wa kopa hore o tlo o yetse ho bona di phuputso ka hore o nke di swab tsa masaledi a phofu ya ho thunya hore o tlo bona hore na haebe ha ona harabona ya ileng a thunya?
Che anga ka ka ho yetsa.
No, I didn't do that.
Why not?
Angizange ngikwenzeke ukuthi labo ababephakathi endlini kade kuthuthuka ukuthi ngenza uphenyo kubona ke ezandleni ukuthola ukuthi angayinsalela yini zesibhamu noma ke okukhona owadubula nkathi ke udutshulwa phakathi endlini.
Mr. Mosia, you need to tell this court the truth. You are at the crime scene. You have received information that someone has been shot inside that house. And people who were present during the shooting incident were still there. What made you not to conduct that crucial investigation of taking a gunshot or prime residue from their hands, all of them who were inside or who were present when the incident took place?
o kopa hore o bolelle lekgotla lena nnete hobane o ile sebakeng seo sa ketsahalo hore o lo etsa diphuputso. Jwale ha o se o fihla moo ho tla jwang hore e re o sentse o bolelletse hore motho a thuntseng o teng ka hare ho ntlo eo, ebe o hloleha hore ka hare ho batho bao ba fihletse ka hare ho ntlo, ebe o kopa hore o nke masaledi o bone hore ha ona hara bona ya thuntseng.
Nna ke latela dintlha tsa motho a fihlileng pele ketsahalong eo. Ke sebeletsa hodima tsona hobaneng e le leponesa e le hore ke motho e re sebetsang mmoho, o tseba ka mokgwa re sebetsang ka teng.
I proceeded and followed up on the information that I already retrieved from one of the colleagues who is a police officer and who was at the scene first, and he knows better as to how we do our work.
Ongakwenza ke mina ukuthi ke ngingakwenzi lokho noma ke lo msebenzi ongibuza ngawo ukuthi ngafika ke ngalandela noma ngase ngiqhubeka ke kulokho engikutshelwa yiphoyisa engafika lilapha yana futhi elaziyo ukuthi sisebenza kanjani.
Who that police officer was?
Ke mang lona leponesa le ile ngwa sala morao ho se a se buile?
Ke Brigadier Ndlovu.
It's Brigadier Ndlovu.
Khuluma ngaye ke Brigadier Ndlovu.
Ha ho na le bohlokwa kapa ho na le pelaelo ya hore batho ba ne ba le ka tlung ba ne ba hloka hore ba nkwe PR test. Ke ne ke tla kotswa ke le focus ile teng mo ketsahalong hobane nna ke letsoho la detective. Ntho e nngwe le nngwe a e hlokang ha ke le teng crime scene ke yena a tlameileng ho lemosa hore re sebetse ho kae.
If there was a need for me to conduct a PR test, I would have been informed by my senior who arrived first at the scene, as I am the assistant.
No, I'm assisting the detectives on a crime scene.
Okay. As I am the assistant of the detective for when we are at the crime scene.
Uma ngabe sasikhona ke isidingo sokuthi ke ngikwenzeke lokho ngangizocelwa ke uyena ke owumphenyi walo icala ngoba ukubakhona kwami lapho ku crime scene mina ngikhona na njengomuntu olekelela abaseshi becala.
How are you going to be assisted by Colonel Ndlovu? Because you told this court initially that you left the crime scene because Colonel Ndlovu was useless to you. He couldn't assist you at the crime scene when you were stuck and you had to leave, or when you encountered difficulties, when it was beyond your capabilities. Colonel Ndlovu was next to you, but you had to leave the crime scene and he was useless.
Jwale o no lebeletse hore Colonel Ndlovu a o thuse ka mokgwatsela e feng hobane wena ka bo wena bopaking ba hao hlalositse hore o ile ba na tshwanela gore o tlohele sebaka seo sa ketsahalo hobane o hlokomela hore Colonel Ndlovu hana molemo ho wena ha gone o thusa ka ntho tse o di hlokang bakeng sa ho etsa mosebetsi wa hao
ntle le ho hloka molemo.
Please, I understand the robust language that my learned friend uses, but to describe someone as useless, I don't think it's appropriate. I suggest to my learned friend that she should maybe temper, her use of the language in this court. Thank you.
Advocate Shololo,
My lord.
we did speak about the usage of language.
As the court pleases.
So as to preserve at the same time the decorum
As the court,
of the court, and to label someone as useless.
as the court pleases.
I think it goes beyond.
My lord, as the court pleases, my lord, I will refrain, my lord.
Yes.
I don't know whether I should repeat the question, my lord.
Yeah, you'll repeat it after tea.
Oh, thank you. Apologies for, it's just that I was irritated by the answer I got. But I want us to take us through this. Did you take any gunshot residue from the hands of the people who were inside the house when the incident took place?
Now,
Well, the witness has already said she didn't. That was the point of repeating the question.
Leo? I think I also have it on record, he didn't.
Sorry, my lord.
He didn't.
Okay. You did not.
ora ha wa ka wa nka-
I did not.
I
Thank
did
you.
not.
I wanted to get it from you, Mr. Mosi, that you did not. Okay?
Understood.
And the reason why you did not perform such a crucial investigation is because you were not told by Colonel Ndlovu. Is that correct? Am I correct?
Ha wa ka wa etsa mosebetsi wa hore o nke masaladi a proof ya sethunya matsohong a batho ba ne ba le moo ka hobane Colonel Ndlovu ha o jwetsa hore o etse jwalo. Nna ho jwalo.
Kelellong ya ka ke ile ka ferekantsho ke hore ke tla tlameha hore ke bitse crime scene management ho ya ka ho latela ka protocol ya mosebetsing hore ba tlo joina re tswedise pele ho fuputsa ketsahalo eo.
I got confused by the fact that I would now have to call the crime scene management so that they should come and join me in further taking the evidence at the crime scene.
Imbangela ke yokuthi ngingakwenzike noma ngingawenziki umsebenzi ukuthi ngenze uphenyo kezandleni zalabo ababesendlini ukuthi ngadidwa ukuthi ke basengithathe isinqumo ke sokuthi ngizobiza i-crime scene management noma ke i-trust team ngilinde yona ke ukuthi ize izongilekelela.
You, on your own, as an official photographer who attended the scene, you did not see it necessary to conduct such an investigation of taking a prime residue immediately after the incident from the people who were inside the house when the incident took place. You on your own.
Wena ka bo wena jwalo ka setsebi se nkang ditshwantsho se tlileng ho tlo fuputsa sebaka sa ketsahalo ya ba ha o nke qetho e jwalo ya hore o kgone ho nka di masaledi a proof ya sethunya matsohong a batho ba ileng hore ba ne ba le sebakeng sa ketsahalo hang ha o fihla sebakeng seo.
Ne se ke hlalositse hore nna ke controller ke dintlha tse ke di tholang ho officer e ke tholang ho crime scene and ha hona ka mo nkekeng ka mtshepa ka teng hobane ke motho wa molao ke mothola ho crime scene nna ke tla sebeletsa hodima seo ang tswetsang sona hore o thotse ho le jwang ho etsahala eng.
As I already alluded to the fact that I will be controlled by the information on which I received from the officer who arrived first at the scene, because I have no reason not to trust them because they were of their experience in doing the job.
Bese ngishilo noma ngichazileke ngaphambilini ukuthi mina ke bengithi ke ngilandeleke noma lo engikutshelwayo iphoyisa ke engifihle likhona lapho futhi ke ngingenaso nesizathu sokuthi ke ngingamthembike kulokho angitshela khona.
Okay, but what I want to get it from you, Mr. Mosia, is that you as a first police officer, as a first forensic officer at the crime scene, you did not see it necessary, you on your own, to conduct such investigation. You did not see it necessary, you on your own. I understand the procedure and the protocol, but on your own, it never rang into your mind.
It never.
Akuzange ke kungifikeleke kwami umcabango noma kwami umqondo ke ukuthi angikwenze mina ke ngingalalelanga nje omunye umuntu.
And Mr. Mosia, do you agree with me that a prime residue ought to be lifted immediately or as soon as possible after the incident has taken place, because it doesn't take long from the hands of people
O dumela
or of
hape
a
hore-
person?
hore phofo kapa di-residue tsa se motho a thuntseng tlamehile di nkuwe hanghang sebakeng sa ketsahalo hobane ha di nke nako e telele di ntse di saletse mmeleng wa motho kapa dikobong tsa diapere.
Ke tshepa hore ho jwalo empa le ha e ne e se e le nako e telele seo se etsahetse le metsamao ya bona batho bao e ne ka nna ya sitisa o kapa ya qhala phofu matsohong e ne se e le ka mora nako e telele ho etsahetse ketsahalo eo.
It was long after the incident had taken place, and I believe that the movement of the people who were at the scene of crime, that process alone could have made the residue to be eliminated or to be messed up.
Are you
bese kunesikhathi eside ke noma ngifike mina ke lapho kwendawo yesehlakalo emuva kwesikhathi eside isehlakalo senzekile ke ukuhamba kwabo ke kule ndawo nalokho kungenza ke ukuthi impuphu leyana ke yesibhamu esalelayo ezandleni noma ezimpahleni iphele noma ke inyamalale.
Mr. Mosia, please listen carefully. I said to you, do you agree with me that a gunshot residue doesn't last? So it ought to have been taken immediately or as soon as possible after the incident. Do you agree with me or not?
O batla o tseba hore na o dumelana le yena ha a re masaledi a phofu ya sethunya ha motho a qeta ho thunya ha dule nako e telele mmeleng wa motho matsohong kapa diaparong jwale hang ka mora ketsahalo tlamehile ebe ho nkwa bopaki bo.
Ho jwalo morena.
I do agree with you.
Ngiyavuma ke ukuthi ke le mpuphu leyo ke ayihlali isikhathi eside ezandleni noma ke kwingubo eqokwe umuntu emuva kokuthi umuntu edungulile ngakho ke kufanele ukuthi ungathathi isikhathi eside ukuthi lolo phenyo lwenziwe.
Okay. Thank you very much, Mr. Mosia. Now that it was not taken by yourself as a forensic expert who was at the scene, don't you think that that evidence would have assisted this court to see if there is anyone who fired shots inside the house where the deceased was shot?
Hobane wena jwalo ka mofuputsi ebile o le setsebi sa ba forensic a fihlileng pele sebakeng sa ketsahalo o hlolehile hore o ka nka diphuputso tseo kapa masaledi ao a sethunya ha o nahane hore seo nka be se thusa le khotla haholo hore re kgone ho tseba hore ho batho ba ne ba le ka hare ho ntlo ha hona ya thuntseng na.
Ho jwalo morena.
It is true, we should have helped.
Kuyiqiniswa ukuthi lokho bufakazi buzoyisiza ke lenkantolo ukuyitshengisa noma ukuyikhombisa ukuthi mhlasimbe noma mhlambe akekho na kulabo ababephakathi endlini owadubula.
And as a result of such an omission on your part to conduct the investigation of the prime residue, there is no evidence to say or to prove if anyone from the house fired the shot as a result of the omission, your omission.
Ka baka la hobane wena ha wa ka wa etsa mosebetsi wa hore o nke o etse diphuputso ho batho ba ne ba le teng ka ho sheba ho bona hore ha ona a nang le masaledi a phofu ya ho thunya jwale seo se etsa hore re se ra fihlella ho bona hore ho bona na hona le a thuntseng kapa tjhe.
Ho jwalo.
That's correctly so.
Kuyiqiniswa ukuthi ngomngawenzi ke lo msebenzi noma lelo phenyo leyo ke inkantolo ayikwazi ke ukwazi noma ibe nolwazi lokuthi akekho yini kulabo ababephakathi endlini owadubula.
Then let's move on now. We have failed to do that. Okay? We are now moving to the hanging of the bedroom door. You remember? We've touched that, which was also touched by the perpetrator and the witness who was inside the house.
Re khutlela mane monyakong handling ya monyako e leng hore o ile wa etshwara ene re dumela hore ile a tshwara ke bona batho ba phepeleditseng ketsahalo ena le batho ba neng ba le teng go bontsi.
You remember that one?
I recall that.
And also no swabs or no exhibit that was retrieved in that area. Am I correct?
Ebile ha ho a
In the
ka
door
hwa
handle,
nkuwa-
sorry my lord, from the door handle.
ha ho a ka hwa nkuwa di-swabs kapa bopaki bo itseng monyako mo door handling hore o kgone ho fumana hore na ho na le se ka fumanehang.
Bopaki bo nkile ka ba evidence swap mo door handling mo bundling re makile as bedroom 1.
Okay.
Bopaki ba menwana le bona bo nkile bo teng mo bundling ya exhibit B. Di edinepeng re ke bona. Ke tshepa hore ke page 72. Photo 72 of exhibit B. Ke yona photo bontshang letsoho la ka le swapo swapang monyako wa bedroom ya pele.
Okay. As referred to exhibit B, photo number 72. As it depicted on the photo, it is my hand with a swab, taking the swab from the handle of the door, referred to as bedroom 1.
And
Nanjengoba sibona-ke sorry, nanjengoba sibona-ke kulesa sithombe siwu-72 isandla sami-ke lesiyana naloko esikuphethe ila khona-ke ngenza-ke uphenyo kuleya kamera bathi-ke u-bedroom 1.
Mr. Musia, don't confuse yourself. You have just told this court, when I was cross-examining you, to say you did not take the swabs from the door handle of the bedroom door that was touched by the perpetrator. I put that question to you and you considered, you said no, it was not taken.
Warabetse potso e reng wena ha wa ka wa nka diswapo tsa bedroom monyako handle ya kamora.
potso ine e lebane le monyako wa kitchen mo ke leng ka dumela hore ha re ya ka ranka swapo ka lebaka la motsama wa batho ba ne ba le ka tlung le ka mo ketsahalo ine e le ka teng.
The question I responded to was about the kitchen door because of the movement of the was confined.
Umbuzo wangaphambilini-ke othi-ke bengithe kuwona-ke angizange ngiphenye ubufakazi kuwona bekuwumbuzo omayela nesicabha sasekhishini la ngishilo-ke khona ukuthi akunabufakazi obathathwa ngenxa yokuthi kwakunabantu abaningi ababehamba khona lapho.
I don't know why you're confusing yourself. I'm not talking about the kitchen door, Mr. Musi. I'm not talking about the kitchen door. I am referring to the door handle of the bedroom. Not the kitchen.
Did you hear his answer?
Sorry, madam.
His answer is that the door handle on which no swab was taken, according to him, is that of the kitchen, and meaning that on the bedroom door a swab was taken. That's his answer.
Thank you, my lord. But I'm saying, my lord, in this court, the same witness, when I was cross-examining him, he did say no swabs that were taken from the handle of the door that was touched by the perpetrator.
There you are.
I think, my lord, the problem arose when my learned friend did not qualify her question. Her question was just simply that the handle of the bedroom door, that there were no swabs retrieved there, without specifying as to which bedroom door she was referring to. I think if now that it's qualified, the witness will be able to respond to that. Because it did appear that she's referring to the one that was touched by the perpetrators.
My lord, I will just leave it for argument because it's there on the record. I'll just leave it and move on, my lord.
Whilst you do that, Mr. Musia, let me put it this way. How many doors are inside that house, if you remember?
E ba o sa hopola hantle Ntate Musia, menyako e ne le teng ntlong eo e ne le mekae kaofela yona?
O ka hara ntlo e ne e le 4.
Inside the house there were 4 doors.
Ngaphakathi endlini kuney'capha eziwu-4.
Bedroom 1, bedroom 2, le bedroom 3, and a toilet door.
Okay. Those doors are for bedroom number 1, bedroom number 2, bedroom number 3, and the toilet door.
Iy'capha ey'ntathu zamakamela okulala nesicapha esisodwa sase-toilet.
Now, because I want you to put me into perspective, because when they argue, after you have left, I will not be able to tell east from west. Did you take swabs on any of the doors? And if so, which are the doors on which you took a swab, or from which you took a swab, and which are the doors from which you took no swab?
Hlalosa he hore menyakong e kaofela sebakeng seo sa ketsahalo ntlong eo ke efeng menyako e leng hore o ilang ka di-swabs ho yona le hore ke efeng e o sa ka ngwang ka di-swabs ho yona?
Ke nkile swab bedroom 1.
I took the swabs in bedroom number 1.
Ka nka di-swab bedroom 2.
I took the swabs in bedroom number 2.
Ka nka di-swab toilet door.
I took the swabs also in the toilet door.
Ke tsona fela tse ke nkileng di-swab menyakong.
Those are the only doors on which I took the swabs.
Iy'capha-ke engasebenza kuzona-ke ngibheka-ke ukuthi akunobufakazi obusele noma obasala yini ikamera lokuqala elesibili kanye naso-ke isicapha sase-toilet.
Okay. How many bedrooms are there in that house?
Phapusi tsa borobalo di kae ka hare ho ntlo eo?
3 bedroom.
There are 3 bedrooms.
Mathathu-ke amakamera okulala noma mathathu amakamera okulala kuloya muzi.
So you did not take the exhibits from all the bedroom doors. You only took for the 2 bedrooms and the 1 for the toilet.
Jwale ha wa nka di-swabs ho dikamore diphapusi tsa borobalo kaofela ha tsona. O entse tse pedi fela le toilet.
Ho jwalo more.
Which is the bedroom from which you took no swab?
Ke kamore e feng e bang ha wa ka wa nka di-swabs ho yona?
Ke bedroom 3. Kopa o sheba mo di nepeng tsa ka hore ka hlaha na.
Can I confirm by referring to my pictures as to which bedroom it was?
Okay, sketch plan. Okay, nka re fera ka sketch plan mren. Page 10. Exhibit A.
I will refer to Exhibit A, page 10. Exhibit A for page 10. Page 10.
No, it's not. It must be.
And Exhibit A in page 10 shows what?
Sketch plan, Moren.
Exhibit A, page 10, it shows a sketch plan For the house,
Yes?
Salus.
And bedroom 1 e re ikileng swap ho yona ke e lebaneng le kitchen. Nyakwa teng o lebane le kitchen mo hona ho mo Kelly a itana ho tsweng o ikwalletse teng and ho pushwa monyako ke bahlasedi.
Okay. According to the sketch plan, the bedroom door on which I took swabs is the one that is directly, which door is directly facing the one of the kitchen door. That bedroom door is the one on which it was alleged Kelly closed or locked herself in, and the attackers pushed that door as they wanted to get in.
Isicabha ke engasebenza kusona ke ilesi ke la esikulele kamera futhi ke sona ke sibhekene nesicabha sase kitchen futhi ke ile camera ekwakuthiwa kulona ke uKelly wayevalele kulona futhi ke laba ababehlasela bephusha lapha yana ngenhloso ukuthi befuna ukungena.
And bedroom 2 ke kopa ho lukisa mo bedroom 2 ikar ke yona Hearsay swapang ke yona e haufi le bedroom 1.
Bedroom number 2 is the one on which we did not take swabs from. It is the bedroom that is just next to the one where Kelly got inside.
Ikamera ke lesibili ke noma bedroom 2 ilona ke engazange ngisebenze kulona ke ngoba ileli eliseduze naleli uKelly wayevalele kulona.
Yes?
Thank you, my lord. Mr. Mosia. At the crime scene,
I'm sorry, Madam. Can I just ask that answer be repeated so that it can properly be noted, my lord? I think this is very important. There was a difference in the interpretation of both languages. If it can just be recorded again.
You want him to repeat the answer he gave?
Yes, my lord.
Okay. Mr. Musia?
About the second bedroom. O itsenga pese ya bobedi.
Kuri ya ke ya ibatla in sokodisa hobane a ke ya maka mo sketching o tla batla ke tsamaye through the preparation.
Buseletsa karabo e o ibuile. Ke jang.
Ke tse bedroom 1 ke lebane le kitchen, bedroom 2 ke Hearsay swapang.
The second bedroom is the one that we did not take the swabs from.
Leli lesibini ke ikamera ileli esingazange ke noma ingazange ke ithatha ama swab kulona.
Bedroom 3 ke e pila toilet ke haufi le toilet le teng ringile di swab teng.
And bedroom number 3 is the one that is closer to the toilet, and we took the swabs from that door.
Lesithathu ke ikamera noma bedroom 3 ke ilena eseduze ke ne toilet ila sathatha khona ke na ubufakazi.
are you done?
And then ibe toilet door inele di swab tse re dinkile menyakong kaofela tse.
And the other place on which we took the swabs is the toilet door.
Omunye ke umnyango noma isicabha ke kwakuyilesi esase toilet.
Yes?
Yes, yeah. This witness, Your Lordship, is testifying about Exhibit B, which is Matlato, the one where Matlato was taking the photos and directed by Lieutenant Zwani. If we can go to Exhibit B, page 19.
Yes?
Page 19.
Yes?
Yeah, where it says is by Matlato. It says, points indicated to me by Lieutenant Zwani on 2014-10-27. It's not this witness. So I want to believe that it's because if I had it well, the state advocate Baloy said will call Matlato. So now I see this is a when he's committing himself on behalf of someone, if we can be know that Matlato is no longer coming from the state.
I don't know whether that is an objection or it's what, because I'm the one who is examining the witness. Is it an objection that I need to respond? What is it? Is it addressed?
Your Lordship, it's an objection. I'm part of the defense here.
You objecting to the question?
Pardon?
Are you objecting to the question?
No, I'm saying it's in relation to the witness, not her. As my colleague, I'm on the side of
the
the
witness
defense.
is answering a question by your colleague, and if you have an issue, note it down. You will comment about it when your time comes.
I just want to say, let the court know that.
Even if you tell me now, I won't remember when it times for you to tell me. Reserve it. You'll tell me when you address me later. Now she is cross-examining. Let us allow her to cross-examine. Let us allow the answers to come, not informed by your views.
Thank you, my lord. Thank you, Mr. Mosia, for the answer. Let's move on now. Inside the house, Mr. Mosia, did you inquire as to where the deceased was when he was shot?
Ka hare ho batho ba ne ba le ka hara ntlo na o ile wa botsa hore mofu o thuntswe a le hokae hantlentle?
O thuntswe a le kitchening.
The deceased was shot whilst he was in the kitchen.
Mufike wadutshulwa nkathi ese kitchen.
I said, did you inquire as to where the deceased was when he was shot? Please listen carefully, Mr. Mosia.
Okay.
Did you inquire?
Re kopa o utlwisise potso hantle ntate Mosia. O ba botsitse batho ba neng ba le ka hare ho ntlo hore mofu ha thungwa hantlentle o ne a le hokae?
Ke ba botsitse.
Yes, I inquired.
Yebo ngabuza ke ukuthi nkathi edutshula umufi wayekuphi nendawo.
From who did you inquire, Mr. Mosia?
O botsitse ho mang kapa ho bo mang?
Ke botsitse ho Brigadier Ndlovu eo e leng yena a lang ang tsebisa ketsahalo eo hore ho etsahetseng ketsahalo.
I inquired from Brigadier Ndlovu, who introduced me as to what transpired at that scene.
Ngabuza ke kuyena uBrigadier Ndlovu kwakuyena wangitshela noma wangitshela ukuthi kwenzakalani lapho.
Were the family members inside the house when you inquired from Brigadier Ndlovu?
Ba leloko ne ba le teng ka nako eo o botsang Brigadier Ndlovu kapa yena Brigadier Ndlovu a o jwetsang tse etsahetseng sebakeng seo sa ketsahalo?
Ha ke fihla crime scene ke thola le polisa crime scene ke itshetleha ho lona hore ke tlo kgona ho tseba hore ho etsahetse eng ke tle ke ke sebedise tsebo ya ka hore ke qala kae ke ya kae jwale ha qeta ho ntsibisa hore ho etsaetseng ke ile ka tlameha hore ke hlokomele hore crime scene ya ka ya hlokomeleha.
Oh, sorry. I have the disadvantage that I can hear some of the things, so
Thank you, madam.
interpret.
Okay, my lord. When I arrive at the crime scene, wherein I would find one of the officers already at the scene, I will depend on the information on which they will furnish me with regarding the scene itself, so that I can know how to execute my duty and how to secure the crime scene.
Okwenzakalayo ke ukuthi uma ngabe ngifika kwindawo yesehlakalo ngizothi ke iphoyisa ke noma uzakwethu engizomfica khona lapho ngibuze kuyena ke ukuthi kwenzakeleni noma kube uyena ongichazelayo ukuthi kwenzakeleni lokho ke kuzongiholela ukuthini ngazi ukuthi kufanele ukuthi ngenzeni noma umsebenzi wami wenze kanjani.
The question was, when you inquired from Brigadier Ndlovu about where the deceased was when he was shot, and when Brigadier Ndlovu responded in terms of telling you or in answer to the question you put, were the family members there? Were they there in the immediate place where that was happening?
Potso ena e bonolo monghadi. Wena
Thank you,
ke re ha o fitla sebakeng sa ketsahalo o bua le Brigadier Ndlovu, Brigadier Ndlovu o jwetsa hore ho etsahetseng sebakeng sa ketsahalo. So potso ke hore ha neng a o hlalosetsa ka diketsahalo tsa sebaka seo ba le leloko ne ba le teng ba mametse ba utlwa seo a neng a o jwetsa sona?
Tjhe ho nka ke ka o netefatsa.
I cannot confirm that with certainty.
Angeke ngisho ke ngesiqinisekiso ukuthi ke babe khona ke nkathi ngibuza ku Brigadier Ndlovu abendlu noma labo bahlala endlini babe khona yini.
Okay. At what stage did you convey the family members to one of the bedrooms?
The question is?
At what stage did you convey the family members to one of the bedrooms?
Kika nako efeng how no o kopa ba leloko hore ba ye phaposing e itseng?
Ha ke qeta ho hlokomela di exhibit tse ke di thotseng ke ile ka hlahisa ho bona hore ha ebe ho tla hlokala hore ba tla batla le hore ba robale ka ba phumule ba ne bana le bana ba banyana ka decide hore ba ka lokoloa ba kena kamereng e lengwe yona e ke mthikileng hore ba khona ho phumula le bana.
After I had spotted and gathered evidence at that scene of crime, because I could observe that some of them had little children and they were tired, I then asked them to use a bedroom on which I marked at the sketch plan for the night to rest.
Okwenzeka ke ukuthi kusemuva kokuthi kunomfakazi ke engakuthola noma engakutosha ke obaphansi futhi ngibona ke ukuthi abanye babo banezingane abayiphethe kubona futhi ke bakhathele noma ikhatheleke ngayo ngase ngibakhombisa ke kwelinye lama camera engiliphawulile khona lapha ku sketch plan ukuthi ke bangayophumula noma bangayolala khona.
Okay. Did you, as an expert, did you make any inquiries as to where are the family members? Where are the people who had been present when the incident took place, so that they can tell me as to where the deceased was when he was shot? Because we all know Ndlovu was not there.
Wena jwalo ka setsebi se etsa mosebetsi wa sona sebakeng sa ketsahalo. Now ke la etsa boikgathatso ba hore o ko o botse hore ba leloko ba kae haholo ba ne ba le teng ka nako e ho thungwang hore ba tle ba re jwetse hore mofu o na le kae ka nako e a thungwang.
Tjhe nka ba ka ho etsa
No, I did not do that.
Ngibabuzanga-ke noma ngifuna ngokwazi ukuthi bakuphi abala endlini-ke ngizokhona ukuthi ngibuze kubona-ke ukuthi ebekuphi nendawo umuphi inkathi edutshula ngoba uBrigadier Ndlovu yona-ke ngaleso sikhathi wayengekho angizange ngikwenze lokho.
And those people who had been present during the shooting incident were the people who could have given you the correct information as to where the deceased was shot compared to Colonel Ndlovu.
Ene hopola hore batho ba e banne ba le teng ka nako ya ketsahalo ke bona ne ba ka o fa he mohlala le lesedi le batsi ka hore mofu ha thungwa ona le ho kae hantlentle hona le Colonel Ndlovu hobane yena ona le siko fihletse ho sontso ho etsahetse.
Ke a dumela empa se ke hlalositse hore dintlha tse ke di tholang ho le ponesa le teng ketsahalong eo ke dule hodima tsona ke sa boneng bohlokwa ba hore ke tle ke botse di victim hore ho etsahetse eng.
I agree with you, but as I already alluded to the fact that I rely on the information that will be relayed to me by my colleague, which is one of the officers who would have arrived first at the scene of crime.
Ngiyavuma-ke ukuthi-ke bona-ke ibona-ke bebezomnikeza-ke iqiniso noma bezomtshela-ke iqiniso kunaye uBrigadier Ndlovu. Kodwa-ke bese ngichazile ngaphambilini ngathi-ke mina-ke uma ngifika ngilandela-ke lokho engikutshelwa yiphoyisa elifike kuqala kunami.
So the spot that was showed to you by Colonel Ndlovu as the spot where the deceased was when he was shot is the spot that you were directed by someone who was not present when the incident took place.
Baka se ho thwe mofu o thuntswe a le ho sona se o se jetsitseng ke Colonel Ndlovu ke sona se o itshitlahileng ho sona le ha kwana Colonel Ndlovu ana le siko ha ketsahalo etsahala.
Ho jwalo hobane o tloa a sa a tseba dintlha ke fihlela ho yena.
That's correct because he would be the one who would have gathered the information prior to my arrival.
Yebo kuyiqinisa ukuthi la ndawo angikhombisa yona-ke indawo angikhombise yona kodwa-ke yena-ke engekho nkathi kwenzeka lokho. Kodwa-ke okwenzekayo ukuthi-ke indawo angikhombisa zona-ke indawo athe athola ulwazi ngaphambilini kokuthi mina ngifike.
So how will this court accept that evidence? Because you got it from someone, it's a hearsay before this court, you got it from someone, and on top of that, who was not present when the shooting incident took place.
Jwale le kgohla le tla amohela jwang bopaki boo ka ho tshepahala hobane le wena bopaki boo ke ba mabare o jwetsitswe ke motho e mong e leng hore o na le siko le ka nako ya ketsahalo.
Empa ke le polisa le yena o tna le karolo mo ketsahalong ya crime scene.
He is also a police official who took part in the crime scene.
Uyiphoyisa-ke noma-ke usho-ke ukuthi njalo umuntu ebengekho nkathi kwenzeka uyiphoyisa-ke futhi naye-ke okwathi-ke wayekhona-ke kuleyo ndawo leyo yesehlakalo.
Okay, let's move on now. You said Colonel Ndlovu told you as to where exactly was the deceased was when he was shot.
Ore Colonel Ndlovu wila a o jwetsa hore mofu o na le hokae ka nako eo a thungwa na ho jwalo.
Ha ne ke hlalosa hore ho etsahetse eng ho ya ka dintlha tsa Colonel Ndlovu hona le ho fekisana kitcheneng mo huileng ha etsahala hore sethunya se thunya mahareng a batho ba babedi e leng deceased le yena moetsi wa ketso eo ka ho ke re ke le ka iponela hore ketsahalo eo e la ka gore e tlameile be e etsahetse hona kitcheneng mo bane ba fekisana teng.
According to the information that I gathered from Colonel Ndlovu is that there were some squabble or wrestle between the deceased and the attackers. That's when the firearm got discharged in the process.
Mr.
So
Mosi,
even when I was doing my own investigation, that's how I could see this thing.
Are you
Kwento
okay?
ke engayitshelwa uyena ke uNdlovu ukuthi ke kwakunokulwisana okwakukhona ke ekitchen phakathi kwakhe umufi na lowo ke wayemhlasela noma labo ababemhlasela.
Mr. Mosi, are you okay?
O santsane o le hantle monghadi?
Ke kgathetse.
I'm tired.
Thank you, my lord. I can see.
Yeah, by the way, he's not very well.
Sorry, my lord.
He's not very well.
He's not well.
Yeah.
My lord, maybe can we just talk a short adjournment to allow him to cool down, and then we'll resume on this issue.
So, Monsieur, whenever you feel not all right,
Yes.
don't wait for some of us to notice. We are too busy with our things. Indicate.
Okay, all right.
Until after lunch. Oh, okay. Thank you.
further and allow the, the medication perhaps to be worked out of his body, we can then adjourn the matter until Monday. It will be the 6th month of June. And subject to confirmation by my learned friend, I think he also mentioned that the medication is also causing a bit of disorientation, hence we feel that it will not be in the interest of the case to proceed further.
Advocate, therefore.
The court, my lord. I want to get instruction from my attorney and my client.
Yeah.
Thanks for indulging the lordship. We reluctantly agree to the postponement. Thank you.
Advocate Kuchalolo.
My lord, I have no objection because there is still a long way to go with the witness. My lord, it would be in the interest of justice to proceed when he is fit, my lord, as the court pleases.
I simply the court, your lordship. On Monday, it's a further instruction that we request to see your lordship and the council in the chambers before we start.
As long as you come with.
I can also mention, my lord, that the next witness is here, but perhaps in the interest of the order of the presentation of evidence, it would perhaps make no sense to make this witness to stand down and to continue with that witness. I'm just mindful of the of the court hours. It's in that regard, my lord, that we feel that it's rather better to adjourn the matter and not proceed with any other witness at this stage.
Well, I would say adjourn and hope that the situation will have improved on Monday. Otherwise, we'll be forced to go that route if he's not well by Monday.
As the court pleases.
Please,
Your Worship, furthermore, yes. And on Monday, may we have the instructing attorney of Advocate Mshololo in the chambers? That's what we beg.
The what?
We request the instructing attorney of Advocate Mshololo on Monday in the chambers.
Advocate Mshololo?
My Lord, I won't respond to that.
Will the accused rise? Due to unwellness on the part of the current witness, Mr. Musia, and by agreement, the case is postponed. With the accused in custody, it's postponed until next Monday, the 6th of June 2022.
ngenxa ke yokungaphatheki kahle kofakazi uSergeant Msiya qala ke lahlehliswa bafethu uhlehliselwa umsombuluko ziyi-6 kuJune 2022 nizohlala ke esitokisini kuze kube ngumsombuluko sizwana. Understood nje?
Anything else?
I can do it.